I don't consider that a tragedy.
No, I'm talking about the kid. My grandfather died and my aunt died.
Neither of those are tragedies. It's life.
Yeah, I understand.
I mean, it's sad that we all have loved ones who die. Tragedy is, when mass shooting occurs and somebody's a victim, something like that, or a terrible car accident for a young person. You're just making excuses because you're living life here, and people are going to die. Unfortunately, we all are. This is case number 26CR43483, State of Ohio versus Connor Heilman. Mr. Heilman is present with his counsel, Craig Newberger. The state is represented by Teresa Hyatt. We are here for a hearing on ILC, treatment in lieu of conviction. What's the state's position?
Your Honor, technically the defendant is ILC eligible, but we are opposing ILC in this particular case. Between 2021 and 2025, he has 13 theft convictions. He has a pending felony 5 theft in Logan County, and then he also had a misdemeanor 1 in Hamilton County that was also pending, at least at the time of the pretrial services report. He's just a thief, and we just feel at this point ILC would not be beneficial, and we would prefer him getting at least on community control.
What would be the difference?
I just feel like in this case he has 13 prior convictions, and to give him a chance at not having a conviction, I feel like is almost, I don't know. I just am opposed to that.
Okay. Mr. Newberger?
Well, I read the assessment, and it looks like he's a good candidate for mental health and substance abuse treatment. Yeah, he steals. He stole $1,029.12 from Target to support a drug habit, and he needs help, and he wants help. And he expressed that to me, and I'm no assessor. I read the assessment report, and I hope the court would seriously consider ILC. Seems that he's come to grips with the fact that he needs treatment and is willing to go the long road to try and get control of a problem that's controlled him for most of his adult life.
Okay, thank you. Mr. Heilman, the purpose of this conversation is whether you should be granted treatment in lieu of conviction as opposed to just either having a trial or pleading guilty and having just another conviction on your record. Do you have anything to say about that?
Your Honor, I feel in deep remorse. Not just, it's like being a menace to society, and I don't want to do that and be seen as this, not from you, not from my kids, not from the staff at Warren County or anyone for that matter. I do have a drug problem, and it's been something I've been battling for like 8 years. I'm just trying to seek help, and I understand that I've given a lot of people a lot of hard times, and I'm tired of doing that.
Tell me why, if you plead guilty in this case, why I should just not give you the maximum sentence of 12 months and be done with it, because you don't appear to be willing to do anything. I guess I shouldn't say that. You don't appear to make the commitment to follow through with anything. You go to treatment programs. You have been through a long list of treatment programs. I don't see much here in the way of violence on your part. I've seen too many people make a commitment and recover from some bad situations to believe you can't do it. Can you give me any hint as to why you haven't been able to do that?
Yeah, there's been some tragedies that have happened in the past 6 years. I've had some problems with my kid's mom and things of that nature, with infidelity and stuff from her part. Well, we weren't married, but you know what I'm saying.
I don't consider that a tragedy.
No,
I
I'm
consider-
talking about the kid. My grandfather died and my aunt died.
Neither of those are tragedies. It's life.
Yeah, I understand.
I mean, it's sad that we all have loved ones who die. Tragedy is, when mass shooting occurs and somebody's a victim, something like that, or a terrible car accident for a young person. You're just making excuses because you're living life here, and people are going to die. Unfortunately, we all are. That's just the way it goes. But you're not coping with things.
Oh, I failed to take accountability as well.
Exactly.
That's
And that's the question. What's going to change here, if anything?
the only thing I can have that's going to make my life any better is my relationship with God, which I'm finding. So
When did you establish that relationship?
I've had a relationship with God for a matter of time, for some years, but within the last 2 years. But in the last few months, aside from relapses in the last 2 years, in the last few months, I've been praying every day. I've read the entire Bible a couple times in the last few months. I've never really read the Bible until these last few months, the entire way through. I've been to church and everything like that, but
Well, you were convicted of theft on an offense that occurred in July of 25. That's the last 12 months. Another theft on July 31st of 25. Another one on July 23rd of 25. Another one on July 3rd. You got charged with aggravated robbery on July 13, but somehow that got dismissed. July 11, 25 theft. So it's in July 2025, 1, 2, 3, 4 theft offenses, less than a year ago. So you started reading the Bible after those theft offenses?
no, I started reading the Bible I've read the Bible the entire way through after this time being in Warren County.
Okay, since you've been in Warren County here?
Yes, yeah.
Okay.
Yes, sir.
Is that going to make a difference?
I believe it is.
Okay.
I don't want to go from a junkie to a Bible thumper and act like that's, I want to be entirely authentic. Between me, you, these walls, and God, I can't lie to him anymore. It's not.
Well, I don't have any answers here. However, I can say one thing. You're in a jail uniform,
Yes, sir.
and you shouldn't be. And you're there because of things you have control over.
Yes, sir.
So, to be honest with you, I don't see much difference in treatment in lieu of conviction and pleading guilty, because if you violate, you're facing going to prison for 12 months, which I really think is the best option in this case, to be honest with you, because nothing else has worked. There's nothing magical about going to prison except the way you're treated might be a little worse. But nothing else has worked. Why would I not do that?
I just want a better relationship with my kids and everyone in my life.
Well, I don't know that it matters what you want if you're not willing to act accordingly.
Yes, sir. I've relapsed many times.
Are you going to do it again?
I don't want to. No.
Okay.
I to tell you no.
Well, that may be an unfair question. I don't know.
I don't want to. I don't want to use crack cocaine or methamphetamine anymore. No.
Okay.
Your Honor.
Okay.
My mom asked the same question, and it breaks my heart now that I don't know how to answer that. So I'm,
Well, I do understand you have a disease, and I do understand that it's in control, but I also understand that you have the power to change that.
I have a sponsor, and that's it.
So I'm not going to grant ILC. Does he want to go ahead and plead?
Yes, Your Honor.
Okay. So,
Do you want a trial? Or do you want to just accept responsibility?
Yeah.
Okay, he wants to go forward with the
okay,
plea.
the reason I'm not granting ILC is it's going to be easier, just a little quicker, to incarcerate you if you don't follow the rules of supervision. If you violate the rules of supervision, we don't have to go back through sentencing like we would if you were on ILC. If you violate the rules of supervision, you'll be on here on a probation violation and you will be gone. I promise you that. Is that fair enough?
Yes, Your Honor.
Okay, so at least you know what's going to happen. Maybe in these other cases you didn't know, and you wouldn't have known if I had been the judge either, because we try to give people multiple chances. But if you come back here violating, you will be gone for 12 months minus the jail time credit you've got. And we're not supposed to send people to prison on a felony 5, but by the time you get through the process of appealing that, it'll be over anyway. So if I can make it more clear, I'll attempt. But if you think you fully understand me, then we'll proceed.
I do, Your Honor.
Okay. You have a constitutional right to have a trial on this matter. You're presumed innocent. The state has to prove the case against you beyond a reasonable doubt. If the state cannot do that, then you won't be convicted. Do you understand that?
Yes, Your Honor.
You have a right to confront every witness who testifies against you at trial. Do you know what that means?
Yes, Your Honor.
You have a right to have witnesses ordered to appear and testify at your request. Do you understand that?
Yes, sir.
You have the right against self-incrimination. Do you understand that?
Yes, sir.
Do you know what that means?
Yes.
Tell me.
Self-incrimination?
Yeah.
I mean, I understand.
You understand, you just can't articulate it, right? I just want to make sure the record's clear. If somebody reviews this, that I made you fully aware of it. You don't have to testify in the case. You don't have to prove anything in the case. You don't have to offer any evidence. If you choose not to testify, it will not be held against you. If you have a jury trial, before you could be convicted, before the jury started deliberating, I would explain to the jury that you didn't testify, they cannot discuss or consider the fact that you did not testify for any purpose. Do you understand that?
Yes, sir.
You plead guilty, you admitted you committed this offense. Do you understand that?
Yes, Your Honor.
This carries post-release control, which is supervision by the Adult Parole Authority, and this is where it gets even more interesting. They can supervise you if you served the full 12 months. They can supervise you for 2 years. It's discretionary, but if they choose to do that and you violate those rules, even if you served the full 12 months, the Adult Parole Authority can send you back without ever seeing a judge for 6 additional months. Do you understand that?
Yes, Your Honor.
And then if you go 5.5 months of additional time and you get out, then if you commit a new felony, the court that has the new felony can revoke the post-release control. They can impose whatever time remains on supervision. But if you have less than a year remaining on supervision, they can still add a year to the sentence in a new felony case. So they could give you another year. Do you understand that?
Yes, sir.
Any questions about your constitutional rights?
No, sir.
Any questions about post-release control?
No, Your Honor.
Okay, tell me before I ask your plea. You've been in jail, what, 105 days?
102 days, Your Honor.
102 days. What happens if you commit a violation of supervision?
I go to prison.
Right. Okay, just want to make sure I understand that. What is your plea to felony 5 theft?
Guilty, Your Honor.
Accept your plea, make a finding of guilty. Got the summary, which would be included in a precedence investigation. I know I've dragged this out. Ms. Hyatt, is there anything else on sentencing?
Your Honor, I believe the recommendation is that he's been accepted into residential treatment at Genesis. We are okay with that at this point. It sounds like if he's willing to move forward with treatment at this point, then that might be a good avenue for him. I believe also Officer Gatch is recommending thinking for a change in 40 hours of community service. We would concur with that. We're also asking that he be trespassed from the target in Deerfield Township. There is no restitution owed because it was all recovered.
Okay, thank you. Mr. Newberger?
Just that hopefully the court will consider what Ms. Hyatt just said. Also, he has to resolve a Logan County felony warrant and a Hamilton County misdemeanor warrant, both for theft, but I'm sure you're already aware of that. Yeah.
Okay. Sir, is there anything further you want to say?
No, Your Honor.
Okay. I'm not going to order the community service because you got other problems going on here that you got to deal with. I am going to order that you complete the Genesis program. Keep in mind, you do not get credit for that. Your jail credit stops when you walk out of the jail. You're on supervision for 3 years. You have to follow the rules of supervision. That means complete Genesis successfully, all aftercare related to that. You'll be on a monitor, abide by the terms of the monitor. I would expect they cover T4C and Genesis, would they?
I do not know, Your Honor. I've not had too many clients there, but I can find out.
Well, complete T4C, but if it's a part of the Genesis program, you don't have to do that separately.
Okay.
T4C is thinking for a change.
Yeah. Yes, sir.
No restitutions being requested. Is there anything else, Ms. Hyatt?
Your Honor, are we trespassing him from target?
Trespass from target means you can't go back to target, not just in Deerfield Township, anywhere, any target.
Yes, sir.
And then did you want him to pay costs?
I'll waive that since he's in the jail.
Okay.
Mr. Newberger.
Nothing further, Judge.
Sir, you have a right to appeal this sentence. You have 30 days from today to file a notice of appeal. If you cannot afford an attorney will be appointed to represent you. Any document you need will be provided at no cost. Do you have any questions?
No, Your Honor.
Okay, that's all. Thank you.
Thanks, Judge.
Judge, would you like him on monitor when he gets to Genesis or upon the completion of
I think
Genesis?
he has to have a monitor at Genesis.
Yeah, I think we just decided when they were here before, so
Yeah.
that was what I was going to ask you. Will you want to do like 30-30 or just while he's there, or?
When he's, sir, when you're going to be on a monitor at Genesis, when you're released, you'll be on a monitor for 60 more days. The first 30, you'll be on house arrest, but you'll be allowed to go to treatment. You'll be allowed to go to work if they help you get a job, anything like that. The second 30, you'll just be on a curfew. Okay.
May I ask, Your Honor, is the court paying for the hookup for the monitor?
I'll waive that since he's indigent.
Thanks, Judge.
Yes. Okay, thank you.
Tad Brittingham, along with Mr. Maniscalco.
Ms. Calco. Okay, I'll add it a syllable. This is case number 04CR21739. We're here for a hearing on expungement. This was a receiving stolen property case. Mr. Maniscalco was sentenced to 2 years of community control with conditions of 30 days in jail and a no-contact order. On April 5, 2005, an entry was filed indicating that the remaining 8 days of the sentence were suspended. He shall have 16 days of community service to complete. That was done successfully. According to this, there's still $352.54 in unpaid financials on it. Were you aware of that, sir?
Yeah, absolutely not.
Okay.
We talked about that today, and I think memory from 20 years ago, he can't confirm or deny that.
Is that a
I
problem?
mean, that would have been taken care of immediately.
Okay. Are you going to be able to take care of that?
Absolutely.
Okay. All right. Is there anything from the state on expungement?
Your Honor, I mean, it's been 20 years since he was terminated from community control, so he's definitely eligible. Other than paying off the costs, we don't have an objection.
Okay,
If the court needs, I talked to him about that today, he could run down the hall and pay that right now and come back.
okay, fine. Well, they won't accept the entry until it's done, so
Okay.
we'll go ahead and have the hearing. He can go pay it, and she'll send the entry over when you give her the nod.
Great.
Is that all right? All right, anything that would show that his interest outweigh any state interest in keeping the record?
Briefly, Your Honor, as mentioned, 20 years ago, he's wanting to close that chapter, show that's not who he is at this time. It's quite frankly not who he was then. It was a mistake that he made. The primary purpose would be for employment reasons, Your Honor. So for those reasons, we'd ask the court make that finding that that outweighs a state interest.
Okay, sir, is there anything you want to say?
Just to sum up on what he said, it's 20 years ago, and despite that, I've been able to have a very successful professional and personal life. And as I continue to grow that, it'd be nice to not have to navigate this burden continually.
Okay. Well, it sounds like you've dealt with some issues regarding drinking, I guess, is.
Well, that was also a long time ago.
Yeah, and you got that under control,
Yes,
and it's clear from just this hearing today that that's the situation. So based on the evidence presented today, it's the finding that there are no criminal proceedings pending. He's passed, the time limit has certainly passed a long time ago for him to have this matter expunged. His interest in having the matter expunged outweigh any governmental need to maintain the records. Is therefore the order of the court that all official records pertaining to this case be expunged. Expunged generally means destroyed. All index references deleted. Proceedings in the case shall be deemed not to have occurred. And the appropriate authorities will be notified to comply with this order. I'll go ahead and sign it. She'll file it as soon as the clerk gives us or if you just let us know when it's done. And congratulations.
Thank you.
Yes, sir.
Thank you, Your Honor.